Large companies face different types of issues than smaller companies when purchasing new technologies, such as software or new hardware devices. Failing to take these issues into account can mean the technology does not meet important and sometimes legal requirements. This can cause the company to not get a return on its investment and have to pivot to a new technology solution, resulting in delays and additional cost. The first issue I'd like to talk about is privacy compliance. Healthcare providers need to be concerned with compliance with the Healthcare Insurance Portability and Accountability Act, also known as HIPAA. HIPAA requires that there be technical safeguards in the technology to comply with the security rule. For example, there needs to be access controls, integrity controls, and transmission security requirements. Colleges and universities need to be concerned with Family Educational Rights and Privacy Act, also known as FERPA. FERPA applies to protect education records, which can only be disclosed with prior written consent. Will the software enable the university to maintain control over the education records by possessing access control protocols and restrictions and using data encryption to protect information in storage and transmission? Financial services companies like banks and insurance companies need to be concerned with a federal law called the Gramm-Leach-Bliley Act. It's a federal law that requires financial institutions to ensure the confidentiality and security of customers' non-public personal information. The technology must deploy technical security to safeguard the information and be regularly monitored and tested. A related consideration to privacy is data protection. Customer data is increasingly becoming an independent key asset of large companies and not just a byproduct of its services. A large company's customer data can be licensed and sold to others to create additional revenue streams. In order to do so, however, the company must retain ownership of its data and all of its dealings with software vendors. You must also understand how your data is protected. Where is it stored? Is it stored locally on the company premises, or will it be stored in the cloud? If stored in the cloud, is the data center located in the United States or in a faraway country? How often will your customer data be backed up, and who is responsible for doing so? Does your software vendor maintain a disaster recovery plan to protect your data? Do they test it often and show you, the client, the results? Do you have the power to wipe data from hardware like mobile devices and laptops remotely to help prevent or mitigate losses in the event there is a data breach? Finally, how do you get your data back when the relationship is over? In what format? In what time frame? And is there fixed in the agreement a transition period so that you can be covered in the event that your transition to a new vendor takes longer than expected? Compatibility is also a consideration that large companies need to consider when acquiring new software, because large companies over time will acquire software on a piecemeal basis. This can result in multiple legacy systems, and those legacy systems may not be compatible with the new technology, so that the new technology may require the development of interface, bridges, and other types of licensing that may be a hidden cost aside from just purchasing the new technology. Purchasing technology can get complicated quickly. You may want to consider securing experienced intellectual property counsel to assist you. It's important that your written agreements for new technology purchases reflect the regulatory compliance required and the type of data protection you need to keep your business in compliance and receive maximum value for your investment.